Welcome to Embargoed, a podcast featuring intelligent talk about sanctions, export controls, and all things international trade for trade nerds and normal human beings alike. I'm one of your hosts, Brian Fleming. I am here, as always, with my friend, colleague, and co-host, Mr. Timothy O'Toole. What is up, Tim?
It is a pleasure to be here, Brian.
Yes, as you'll note, I am once again hunkered down in my virtual library where I plan to stay until after Election Day for various reasons. So that's where I'm recording today.
Are you taking your Regeneron while you're down there, just so that you will feel better than you have in the last 20 years?
I'm gonna pass. I'm gonna demur on that question and not answer. That's a matter between me and my doctor. But
that is a
HIPAA protected. Yeah, we're not about violating any privacy laws here. But in any event, welcome to Embargoed. As always, thanks for listening in this week. Thanks as always to those of you who reached out after our massive deep dive into the TikTok and WeChat mess on the last episode. We're gonna briefly revisit that this time, but we promise it will be brief, and then we will move along. Yeah, pretty enlightening in our treatment of TikTok and WeChat this week. So before we get started, as always, we're not here giving legal advice. We are not discussing any confidential information, including confidential health information. And if you enjoy the podcast, you can find us anywhere you get your content: Apple, Google, Spotify, Stitcher, Overcast, YouTube. If you want to see what my virtual library looks like and try to guess how long it's been since Tim got a haircut, you can find us on YouTube. And if you enjoy the pod, please give us a rating, a 5-star rating. Tell your friends, tell your family, tell your colleagues, pass along the word about Embargoed, especially as things are heating up here in the run-up to Election Day, as I've already alluded to. So I think we want to get right to it. Any thoughts before I kind of give the rundown and we get started?
No, I mean, lots of stuff happening, and a lot of it is not in China this time.
Yeah, only a little bit of China this episode, and we had some sort of late breaking news relating to Iran that we were actually planning to talk about anyway. Scout's honor on that one. We really did have that on the list of topics for today, but
I can confirm that Brian sent an outline actually about 4 days ago with that topic on it as one of the topics.
Yeah, which we're never that organized, or we usually wait until the last second to stay timely. But in any event, so here's what we're going to cover today: a quick check-in, number one, with TikTok and WeChat, because there have been a few things that have happened since the last episode. Actually, between when we recorded the last episode and when the last episode was posted, the big event happened. And so we'll talk about that briefly and check in there. Then we're going to move on to the lawsuit that was just filed a few days ago, challenging the executive order and the regulations imposing sanctions on the International Criminal Court. Then we're going to move to the advisory that was just issued last week by Ofx and Fincen relating to ransomware, and in particular, sanctions and other regulatory risks in connection with payment of ransomware ransoms. It's sort of an interesting topic that's been sort of kicking around in one fashion or another for a long time, but I think it's this sort of the pandemic has brought this to a head, and so we got an advisory on that we're going to talk about. And then the last item for the main part of the show is a recent OFAC enforcement action focused on Cuba, and in particular travel and insurance and some of the sort of favorite topics with respect to Cuba. So we're going to talk about that briefly. And then in the lightning round, we're going to hit on, I think our lightning topics are actually pretty beefy. So they're not going to be big distinctions between those and our regular topics. We're going to hit the expansion of the Iran sanctions to basically every other financial institution in Iran that was not already sanctioned. That just happened literally 2 hours ago. We're recording late in the afternoon on Thursday, October 8th. and this just happened earlier this afternoon. And then we're going to wrap up with a ruling that came down a few weeks ago. We missed out on it when we did the lightning round episode relating to the lawsuit that had been filed by Federal Express, challenging essentially the entire structure of the export administration regulations. So we are going to, it got a lot of attention when it was first filed last year in the early summer of 2019, and it's now come to a close, it seems, with a bit of a whimper. So we're going to talk about that, and that'll be the show for today. So with that, any thoughts before we get going, Tim?
No, a lot on the plate, but I think we're going to get through it quickly. I'm optimistic.
I think so. So let's start with item number one. As I said, TikTok and WeChat. We can't quit TikTok and WeChat like much of the U.S. and global public. So when we last left you, we were a few days away from the WeChat ban had been enjoined by federal court in Northern District of California. That remains the case. And in DC, there was a litigation pending relating to the TikTok ban. And we knew that there was going to be some action in all likelihood on a preliminary injunction that had been filed to prevent the September 27th aspect of the ban, which was going to be targeting app stores and distribution of the TikTok app through those stores on September 27th. And that is in fact exactly what we got. On the 27th, federal district court judge in DC granted the preliminary injunction only with respect to that one aspect of the ban, which was set to go into effect on September 27th, relating to app stores. Everything else was punted and sort of put off for down the road. And those are the aspects of the ban that are going to go into effect in November that were sort of time to coincide with what is supposed to be the conclusion of the CFIUS review process relating to the TikTok divestiture to Oracle and Walmart and other U.S. investors. So that's basically what's happened. There has not been, since the injunction was announced, that's basically the end of the sort of big headlines. So there's a scheduling order in place now in that case where the parties are going to brief up the rest of the ban, the November pieces of the ban that are supposed to go into effect, and that briefing is going to happen throughout October. And if the case is still live because there's no divestiture, we will likely get a ruling on that right before the November deadline hits. On the WeChat side of things, they are arguing in the Ninth Circuit about whether there should be a stay of the injunction pending appeal, and that's really where things stand there. So at the moment, and if you're keeping score at home, the government is 0 for 2 in their bans on the timeline that they had originally intended to impose them. So there are no bans in place right now. On top of that, very quiet in terms of what's going on with the CFIUS review, and perhaps more importantly, the review going on by the government in Beijing of whether the Chinese government is going to sign off on this. So we don't really have much more on that from where we were, 2 weeks ago. I don't know if the silence is ominous or what's going to happen, but it doesn't look like this is going to get resolved anytime soon. It looks like this is probably going to drag out all through October, maybe past the election, all the way into November, if I were guessing at this point. Let me throw this. So that's kind of where things stand. That's a snapshot of where everything is. So that's a lot simpler than where we were trying to explain what was going on the last time. Let me throw this to you, Tim. So the PI that was granted in the WeChat case, First Amendment grounds were the grounds there, as we talked about last time.
Yep.
In DC, on the TikTok ban, it basically fell. The plaintiffs prevailed on the Berman amendments and on the fact that they demonstrated a likelihood of success on the fact that this restriction impermissibly regulates informational materials and personal communications, which are carved out of IEPA. And that is really the lone ground that they prevailed on in front of the district court judge in DC. So let me throw it to you there. What are your thoughts on that? That's a pretty consequential decision in terms of impact, not just in this case, quite frankly, but in many other cases and many other exercises of sanctions authority, in particular purely via executive order. In the ICC matter we're going to talk about in a few minutes is kind of may follow the same pattern or same types of arguments being raised. So what are your thoughts on that?
Yeah, so I'll start with the Berman Amendment ruling related to TikTok. So on that one, I do think it could be consequential in terms of the fact that that sort of ruling could apply to every sanctions program. But OFAC is generally pretty careful in trying to carve out exceptions to sanctions programs for communications devices, for communications practices. There's almost always an exception in the regulations for that. Most executive orders either expressly carve out an exception for personal communication or have a provision that says that this executive order does not restrict things that the president isn't allowed to restrict, which is kind of a nod to the Berman Amendment, because the language of the Berman Amendment is basically the president's power under IEPA doesn't include the ability to prohibit communication. So usually OFAC is much more careful than the Commerce Department was here, and really than the administration was here, because the whole point, I think, of both of these executive orders was to prohibit communication devices. And so it did come into much more direct clash with the Berman Amendment than a lot of these sanctions programs usually do. The other thing I will say about TikTok very quickly is that had the injunction not issued, we would have been deprived of the opportunity to see the Nathan Apodaca TikTok video. He's the Idaho Falls guy who was skateboarding to work and drinking this gigantic jug of ocean spray cranberry juice. Hat tip to my wife for showing me this video. It's apparently become a huge sensation. He's also apparently singing along to Fleetwood Mac's Dreams, and Mick Fleetwood then made his own TikTok video that went viral. None of this would have happened but for the injunction. And so that really is the line where our area of expertise crosses with the real world and important aspects of American culture.
Well put, and bringing it all into some perspective. Just on your first comment, I agree completely. And we've talked about this a few times now since the executive orders were put out. It always struck us that this was sort of hastily put together, hastily conceived and rolled out. And there was definitely the prospect that this tension was going to sort of blow up in the government's face in terms of not construing or tailoring the restrictions in a manner that would survive challenge for these carve-outs. And that at the moment seems to be where things stand. So it will really be fascinating to see what happens if the deal falls apart. let's fast forward to a reality where the deal doesn't get finalized or approved by either the US or China, and we end up in a situation in mid to late November where we are still with the same, TikTok's ownership is the same, ByteDance still has its same ownership, data remains where it is now, not in the hands of a trusted US company. What is going to happen, especially if more aspects of the restrictions end up getting enjoined, if this does get litigated in come early November, the judge in DC rules that other aspects of this also fail to pass muster. So will the government do a pivot, do a 180 and go back and try to rework the EO, or are they just going to fight this to the death until maybe they push this up to a friendlier circuit court or the Supreme Court, certainly, to try to win the day? Of course, that's going to take a long time. So I don't know that they would have the patience for that, but that's what we could be looking at here.
Yeah, I mean, so I did want to say a couple things about WeChat if we're moving over to that, because I agree that that it's one of the things that is interesting about WeChat or the WeChat litigation is that the government has withdrawn. I mean, it's withdrawn both of these, both of these orders,
Prohibitions.
both
Yeah.
of these prohibitions, which I find a little bit odd because, normally, if there's a law that's being challenged, it stays on the books during the challenge, and then if the challenge fails, the law just goes into effect like it was supposed to, and if the challenge succeeds, then the law is still on the books, but it's enjoined. Here they pulled it off the books, which means that even if the injunctions were to be lifted, they'd still actually have to go to the trouble of putting the prohibitions back in place, which isn't that hard, but it's just I'm having a hard time understanding why they went to the trouble of pulling them. One hint, I was kind of piecing through there's continued district court proceedings in the WeChat litigation, although it's still up on appeal in the Ninth Circuit. And what appears to be happening is that the government appears to be trying to backfill the record to justify the WeChat prohibition, because one of the grounds that the district court overturned it on as part of the First Amendment analysis is that it wasn't that the government hadn't really stated much of a compelling interest. And so they're trying to show a compelling interest. In the course of that, at least from reading the plaintiff's side papers, it appears that on the question of whether or not they could have used a less restrictive means, WeChat apparently offered up all sorts of mitigation, and at least some branches of the government, these are the documents the government put in to backfill the justification for it. Apparently some of the government actors thought that those justifications were sufficient and that they could have just gone with the mitigation that WeChat had offered for any of the privacy concerns that were raised in the order. And so it does seem to me that this was done quite hastily without a ton of justification. And even now where they're trying to backfill the record with justification, the justification, again, I haven't gone through it enough to know for sure, but it doesn't look like it's even all that compelling now. And so I suspect that if they don't win, and they may not even try to appeal, at least from the documents that I saw, they appealed, but then they said they didn't have the permission of the Solicitor General. And generally when the United States appeals, or at least to pursue an appeal, it needs the permission of the Solicitor General. I don't know if that's happened yet, but it seems possible to me that this just isn't going to be pursued very vigorously because they just didn't do a very good job of justifying it. And then after the election, who knows what's going to happen.
Yeah, one other wild card here that I'll bring up is the idea that the suit, the WeChat suit that we keep talking about is WeChat users are the plaintiffs group there. We still don't have any action from Tencent, the parent company, to dive into this the way ByteDance has dove in on the other side. So that's still a big question mark, and it's still always a possibility that they could get involved more directly in litigation or in some other manner that we haven't seen yet. So, I agree. I think just keep an eye out for that, because it's very difficult to know how it's going to play out. But again, as things stand, as Tim said, the Federal Register notices that actually Secretary Ross put in, a few weeks ago in September to announce the scope of the prohibited transactions. Those have been withdrawn, and if you look for them now, you can't find them anymore. You can read the letter that withdraws the prohibitions, but the prohibitions themselves are literally off the books, are not in the Federal Register anymore. So, very difficult to know kind of where this is all heading. I would just say, as a general matter, I can't imagine that the government is going to give up this one easily. Obviously, the election could have a big impact on how vigorously this gets pursued, whether it sort of fades away quietly or this ends up being a major issue that's going to be fought, for months, if not years, going forward. But we shall see. So with that, let's leave China. And let's go over to the International Criminal Court, and I'm going to throw it to Tim to talk about the lawsuit that was just filed in New York challenging the EO and the regs.
Thank you, Brian. So this has been a continuing saga on the podcast. So back last summer, the president issued an executive order that blocked, or at least allowed the OFAC to block any individuals on the International Criminal Court that OFAC determined were interfering with U.S. foreign policy interests. We talked at the time about kind of how shocking and odd a use of IEPA that was. And we predicted, as it turned out incorrectly, that it would probably just go onto the shelves and never be used. But we talked in a later podcast about how the fact that the president and OFAC then put a couple of investigators with the International Criminal Court onto the SDN list, and so this program is up and running and real. And now, on October 1st, a public interest law center in New York and what the complaint describes as 4 distinguished law professors brought a lawsuit to challenge the entire executive order and the entire program. But the gist of the challenge is that these professors provide services and have interactions with the International Criminal Court. They write about and think about the International Criminal Court. They've apparently provided training to members of the International Criminal Court and to investigators for the International Criminal Court. And although they challenge the entirety of the executive order, what they're really focused on is that in the executive order, like most executive orders that deal with sanctions, the OFAC is given the power to block certain people if they engage in certain types of conduct. Here it was the International Criminal Court investigations that related to the United States. But once someone is blocked, it then becomes sanctionable to provide material support or financial support for someone who has been placed onto the SDN list. And so these professors, the gist of their lawsuit is that they're very concerned about these material and financial support provisions based on the interactions that they've had with the International Criminal Court. And in fact, I think the interactions that they've had with some of the people who've already been listed. And so what this suit argues is that the essentially the vagueness of those provisions violates the First Amendment and violates their right to be able to provide these services and chills the lawful interactions that they might have with the International Criminal Court. You sound like you want to jump in.
No. No, go ahead. Keep going. Sorry.
So no, all I was gonna say is just that on the surface, I actually think that this complaint presents a very serious issue, and we've already talked about kind of our views on the kind of outlier nature of this program generally. I mean, most uses of IEPA involve national security concerns where you've got some entity that is engaging in some sort of conduct, or some country or some government that's engaging in some sort of conduct that you can at least make the case violates international norms. It's very hard to make that case with the International Criminal Court investigating conduct within the territory of countries who've signed on to the International Criminal Court. So it starts out as kind of an odd use of IEPA. And then, there's always a real problem with the material support provisions just generally in terms of the vagueness, because they've been interpreted so broadly that they can't apply to conduct that is protected by the First Amendment and really couldn't meaningfully be regulated or criminalized. But the lawsuit, and we've talked about this a little bit already, paints this picture of this program by talking about the fact that the regulations themselves that have been adopted to pursuant to the executive order don't even provide any more detail than the executive order, and they don't define terms like material support. And then we ask for
foreign persons is another one.
Foreign persons that they don't. Right.
Yeah.
And so, and they don't, and we asked for guidance on this last month, and we told them that it was that we needed it quickly, and OFAC hasn't provided it for us. And so some of the kind of factual statements in the complaint about the program and about OFAC, even though I think we both have our concerns about this program, don't really seem to be all that different from what OFAC does anywhere. And I'm particularly struck by the fact that they're very upset that OFAC hasn't replied to their request for guidance, and it's been pending for weeks now. And they told them they needed an answer in 20 days, and they can't believe that OFAC hasn't responded to that. And it seems like there's some there, I think, but it's buried amidst a lot of stuff that is really very unexceptional to people who follow this, and made to seem kind of almost breathless.
Yeah, I think for anybody who actually interacts with OFAC on a regular basis, I think if you really dug around, there's probably some guidance requests that date back to the Clinton administration that are probably still sitting on someone's desk that haven't been responded to. So, all due respect to our friends at OFAC, that's just the reality. So, yeah, I agree. I agree completely. What this strikes me as is so the extreme distaste for this program among many people in the US and outside of the US from just a sheer policy and perhaps precedential standpoint is one thing, but it seems to really be coloring the lawsuit in a way that I don't know is really warranted, because I think, to Tim's point, all of the things that are being complained about here, as opposed to what we're talking about with TikTok and WeChat, which I think truly are, the executive orders there are truly something different and something we haven't really seen before. This is pretty run of the mill, just in terms of the executive order, the way it's structured, the terms it uses, and the regulations that were issued thereafter. The terms that they complain about not having fair notice of, what does it mean? Unclear what it means to material assist, unclear what it means, who a foreign person is, unclear, those types of phrases. Those are part and parcel, obviously, of every program that OFAC runs. And even if just looking at the specific EO and the regs here, I think there's as much guidance to be gleaned here as there is in any other program. The sort of the fair notice concept, as loyal listeners of this podcast will know, on one of our very earliest episodes, I think it was episode 2, when we talked about the ExxonMobil decision, that introduced the idea of fair notice with respect to the conduct that was at issue in that case, in the context of the Russia-Ukraine sanctions, in a very different, sort of very concrete sort of way. And I think that we speculated at the time that we may see more lawsuits that sort of piggyback on that approach and try to attack certain ambiguous OFAC guidance in certain areas with that approach in mind. This is sort of a half-hearted attempt to sort of do that, but it's also based on, it's all prospective. These are not people who've been penalized. These are people who say they want to engage in certain conduct, or they have historically engaged in certain conduct with the two sanctioned persons who are part of the ICC and on behalf of the ICC and in relation to the ICC. So they have not suffered any actual harm yet. It's all prospective and speculative to some degree. So I think this is very different than that. And I think, they also make there's also some discussion about, well, what is the scope of a prohibited service that you can provide to a sanctioned person? Well, the scope of prohibited services, whether or not it's clearly stated in the regulations or the EO, every enforcement action that OFAC releases virtually has something to do with providing prohibited services to sanctioned parties or sanctioned countries. And so there's literally dozens of examples out there in the enforcement arena that you can sort of glean from there. So the idea that that's a total sort of blank slate, I think, is not entirely true. And there's also some allegations about, well, these are speech-based services, and so that's a First Amendment problem. Well, virtually any service that's being provided where there's any kind of advice being given is a speech-based service, I would argue. And so, again, I don't know that advising or consulting on ICC proceedings is really all that, if you can really distinguish it in any meaningful way from anything else that would be provided from, again, for example, when, in April 2018, when the SDN, the oligarchs from Russia were added to the SDN list, and Rusal and other companies were all of a sudden, people woke up one day and they were on the SDN list. I don't know that I didn't see any lawsuits at the time alleging that there were, speech-based services that they could no longer provide to Rusal and other companies. The reality is, based on whatever the regs say and the blocking, how it impacts you as a U.S. person potentially, or even as a non-U.S. person, you have to make judgments about what you can and cannot do. You can go to OFAC for guidance or a license. They went for guidance. They don't have an answer yet. They're not going to get an answer anytime soon. presumably, but that's how it would typically play out in the normal course. Now, I understand they have some things they want to do later this year, but plenty of people who've sought guidance from OFAC or have put licenses in don't get answers in the time they want. So I don't know that this is all that different than sort of a run-of-the-mill case.
Yeah, I mean, so training somebody how to use a shoulder-fired missile launcher is a speech-based service,
right?
And I don't think that would be one that I would want to be arguing in front of a court. Shouldn't be able to be regulated by
on First Amendment grounds. Yeah,
it wouldn't be OFAC, it'd be DDTC, but still, right. I wouldn't want to make a First Amendment argument based on that. These lawyers obviously know a lot more about the First Amendment and about their case than I do, but I would have framed this in a very different way, and instead of trying to take on this notion that these terms are so vague that nobody can figure out what they are, because they're the same terms that they use in all the programs. And like you point out, Brian, there is a common law of sanctions where if you read the enforcement actions, you can kind of figure out what OFAC is getting at by these terms. Not to say that a lot of them aren't vague anyway. I mean, I thought Exxon, made a very valuable point it made a very valuable contribution to that discussion by pointing out that there's a lot of strategic ambiguity going on, and it's not fair to punish people for that. But I would have thought about framing this case from the perspective of, look, when you're talking about, whether or not people can interact with terrorist groups, those terms might be fine, or whether they can interact with kind of pariah countries. But when you're talking about whether or not professors can interact with the international the International Court of Justice and the ICC and help train investigators, you've got to be more precise. And so I think that this is a case that instead of kind of focusing on these terms just generally, really, to me anyway, what's powerful about this case is the fact that this program is crazy, and you really do think that that I would want to tailor arguments to how crazy the program is, and how, well, these terms might be fine in every other context, since you're not trying to take down every sanctions program, you just want to take down this one, when they are applied to this context. And I would have made a lot more of what a stretch I think this is in terms of IEPA. I mean, at some point, there's limits to what the president can sanction under IEPA. And I would think that an internationally recognized court exercising power over its own jurisdiction would be somewhere where I would want to take that. Like, I just think that they left a lot on the table by ignoring how crazy this program was and how crazy it might be to apply to these facts, and made it seem like these terms are just not fair in terms of sanctions generally. And they point out things about OFAC that maybe courts don't know either, but that it's just standard practice for OFAC. They're not going to give you guidance anytime soon, probably never in a lot of instances. And so you're just going to have to figure out what these terms mean and take your chances. If you ask them and you wait a while and you have a good, strong argument that you're not doing anything sanctionable, you're probably not going to get sanctioned, but you still might. So you do have to take that risk, and it can chill content can chill speech to the extent there's free speech here. So they have something to talk about, but I just think they bit off more than they needed to on this.
Yeah, I think the other issue is, and again, all due respect to the folks who brought this lawsuit, like, we're, tip our hat to anybody who's going to take a run at these issues. Like, these are hard issues, they're challenging issues, so no disrespect meant to any of these people. And we're sorry, we're armchair quarterbacking this a little bit, but I would also say, there's an APA claim in here. Traditionally, we don't see those have any chance of success if we haven't sort of had time for the record to actually be kind of filled out a little bit. There's been no action taken. There's been no time for the agency to even respond to the guidance request. These are the types of things where after a year or two or three of inaction in response to something, maybe there's a fighting chance in court on something like that. Very difficult under these circumstances where it's so fresh. And with respect to IEPA and biting off more than IEPA can bear, they also took the tact of informational materials and the Berman Amendment and sort of played that card again. Again, I think based on what we just talked about with TikTok and WeChat, where it's so core to what is happening and what the purpose of TikTok and WeChat are, personal communications, informational materials. This is just not that. In my view, it's you could make that argument with just about anything, speech-based, informational materials, personal communications. But I just think at core, that's just not really what this is. And I think that a court would have a hard time sort of accepting that that's what this is.
Well, one thing that might happen, I mean, it's too early for a response yet, but they might actually get their victory or their guidance out of a response because, unlike in Exxon, these folks haven't been punished yet, and it's not clear to me that they're within the scope of the order, to the extent that the order likely, I haven't gone back and looked at it, but it likely has a provision that either says that it doesn't apply to communications or it doesn't apply to, it doesn't apply if it's exempt, if the president isn't authorized to prohibit it. And so you could get the Justice Department responding to this in a way that says, no, you guys, this is not what is within the core of this. We're just going after the ICC. So you guys don't, you're coming in far before you should. I mean, sometimes the government does do that and say, you're making a lot out of nothing. We haven't gone after you. And if that's all you're doing, you're probably not within the scope of this.
I mean, I do feel for them because, the Attorney General himself has done some saber rattling and said, we're going to go after everybody who has anything to do with supporting the ICC. And so, I get it. And given the current sort of way that the Justice Department is being run, I wouldn't be surprised if they would be trying to criminally prosecute people who are doing things like this. So I get all that. Totally fair. I'll make one last comment. Then this is actually, I think, taking a little longer than we thought it would. But another approach on the guidance request could have been, and again, not to Monday morning quarterback this too much, we have both seen and perhaps submitted on behalf of clients guidance requests that basically say, we are intending to do X.
Right.
We don't believe that X is a problem under this sanctions program for the following reasons. Lay it all out. Boom, 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 boom. If you think differently, come tell us and we'll stop. But otherwise, we're going to go do what we're telling you we're going to do. Ofx on notice. And a lot of people take the view that, if you notice up the agency in that manner, you're drastically reducing the idea that you're going to really be subject to any significant penalties. Now, they could always disagree and come to you, but if they came to you and said, you need to stop, and you did, then the chances you're going to be subject to enforcement, it's not a guarantee. It's not a guarantee, but it's low. But that's another way to go. And that could have been a way they could have gone here and said, we want to participate in these things at the end of the year. We don't think it's a problem for these reasons. And then it would still be sitting on someone's desk at OFAC, just like their current guidance request is. And they could have made the judgment at the time whether they go forward or not go forward, depending on sort of how they feel about how strong their argument is. But, now they're in SDNY. We'll see what happens. You're right. They might get an answer, either a backdoor answer through the briefing, or maybe OFAC will even respond just to try to moot some of this to the extent they can. So we'll see. Anyway,
one more quick before we get to ransomware. Quick piece of free. It is not advice. It's just a tip. If I were the plaintiffs, I don't think a response is due until after the election. If the government asks for an extension to that, and the election comes out like the polling looks like it's coming out right now, I would agree to that extension. I would try to get the government's answer as late as possible in this, because this matter might go away in 2021 without any further fight. Because I do think that if there is a Biden administration, I do think we're in for a lot of sanctions changes. And this program may not be long for this world if there is a Biden administration.
Yeah, we shall see. And also, Tim, just to be clear, does not have a crystal ball, nor is he a paid political prognosticator. So please don't add us, as the folks on Twitter say, and complain about that. But fair point. All fair
one
points.
Possibility of two. Yeah. I'm just pointing that out.
We warned you on the last episode that the election was going to be creeping into the podcast in a bigger way over the next month, and it certainly is. So I do agree generally with that sentiment, and we'll have to wait and see. So anyway, let's put the ICC lawsuit aside. Let's move to a cheerier topic, not really, ransomware. So as I said at the outset, last week there was an advisory that was put out by OFAC, and also one that was put out by Fincen, which relate to, in a nutshell, the regulatory risk associated with paying ransomware ransom payments. So again, we're assuming most of you out there know what ransomware is. For those who don't, it is malware, malicious software that gets into usually a company or a school or a hospital or some entity's computer infrastructure, IT infrastructure, and basically locks down all the data and makes it inaccessible, encrypts it. And the only way, and then after that happens, the victim company would get a message that says, if you want access to your data, you need to pay us $1 million, or more likely $1 million in Bitcoin to this account somewhere, not in the US, that is going to be much harder to trace, or something along those lines. And this has been a problem, a growing problem for several years. It really was starting to crest when I was still at DOJ, and this was a very high priority for us in National Security Division and at the FBI and other agencies, trying to combat this problem, educate people about this. But it has gotten worse by all accounts during the pandemic, not surprisingly, because there are just a lot of people that are online constantly that are kind of sitting ducks here. And so I think and I would add that the OFAC advisory, so the Fincen Advisory, not surprisingly, is targeted mostly at financial institutions, those who are subject to the Bank Secrecy Act, and is sort of reminding them that there are certain obligations that they have with respect to complying with all of those rules, and also reminding them that they need to be careful if they're going to be involved in any aspect of ransomware payments, processing payments, let's say, for victims, that they are not going to be, there are likely going to be SAR requirements, and there are other potential risks there in terms of potentially engaging in, essentially facilitating money laundering or material support to terrorism or things of that sort. Now, these concepts, I will say, and these notions and these talking points are not new. And again, when I was a justice, I definitely wrote speeches that sort of highlighted these risks for my boss and others at DOJ, to let people sort of have open eyes and open minds about ransomware, and whether if they were considering paying, be aware you could run into these traps of inadvertently facilitating terrorism, inadvertently violating sanctions, perhaps by sending money to a sanctioned country or a sanctioned party. That is really kind of at core what's being sort of underscored here. I think I will just give two comments, I guess, before I throw it over to you. Number one, the message traditionally, I think, was aimed at victims themselves, at companies, or at hospitals, or at universities, or any place that has data that might be worth either stealing or trying to lock down and disrupt operations. And I think that was kind of the main focus. This is actually, I think, quite consciously focused a little bit on sort of the cottage industry that seems to have grown up around ransomware payments, which is sort of interesting. And so it's, digital forensic service providers who are doing, cyber remediation after a breach or after a ransomware attack. It's insurance companies, in particular those who provide cyber insurance. It's not just banks, but it's others in the sort of financial money processing chain, again, sort of payment processors and other currency exchanges and things like that, that are also part of this process. So I think in some respects it's sort of aimed at those folks, and not only making them aware of this risk, but sort of sending a shot across the bow that, you need to be careful. And in particular on the OFAC side, they are clear. They're like, look, we're warning you about sanctions risk. We're telling you that there are a bunch of malicious cyber actors who have engaged in ransomware attacks that we have sanctioned under cyber programs. And moreover, those people, not surprisingly, tend to be associated with Russia, Iran, and North Korea. Three countries where you're going to have heightened sanctions risk if you're just going to be blindly sending money off or Bitcoin off to these places to try to unlock your data, which, by the way, there's no guarantee that it's even going to get unlocked after you make these payments. So I think at the end of the day, it's warning that cohort of people, not necessarily the victims, but sort of everybody around them who is involved in the ransomware payment industry, for lack of a better term. And then it's also the idea that the government wants to take the opportunity to do what they always do, which is to say, if you get attacked, come to us. Call FBI, call Secret Service, call one of the agencies that handles cyber response within the federal government, and let us help, because this is incredibly complex stuff, and trying to do it on your own, you may just compound a bad situation by making it worse, by making one of these payments that get you into even more trouble. So that's about all I have to say about that, but I'll kick it over to you.
Yeah, so this is not an area that I've actually given much thought to. So I read the advisories with interest. The one couple of things that jumped out at me, one is I guess from a lay perspective, I would view the people who've been cyber attacked as victims. And these publications did not really seem to view those folks as victims. It was much more of a, so you've been subjected to a cyber attack. You better not try and deal with the people who did this, or you're going to get in trouble yourself. So it was almost trying to scare the pants off the victims to actually do anything. Now, the other thought that I had when I was kind of thinking through that is, yes, people who are victims often do want to call law enforcement and bring law enforcement in. But on the other hand, they're victims of a cyber attack where essentially they're probably being blackmailed with things that might be unseemly, but also might be illegal. And so the victims of cyber attacks and the use of ransomware are often probably not going to go want to call law enforcement, because they are worried that now I've been the victim of a cyber attack, and the only way that I can do anything about it is to go essentially turn myself in for a crime. And so that it does seem a little more complicated than the advisory said, which was, the answer to everything was to call the FBI. And sometimes people don't want to call the FBI, and for understandable reasons.
Yeah, this is a fundamental tension that continues to persist in the world of cyber intrusions and has from the very beginning, which is the government trying to incentivize victim companies to come forward and work with them so that they can analyze and understand and help, quote unquote, help the situation. And companies or other entities just being scared to death that they're going to make the situation worse, not necessarily because they've done anything illegal, but if sensitive and proprietary data has been stolen or locked down, that's a massive problem just from a business continuity perspective that they may not be able to deal with. Also, these attacks tend to expose flaws in cybersecurity readiness, and that subjects them to lots of potential bad consequences, in particular shareholder lawsuits and other types of privacy-based attacks and lawsuits from whether it be customers or others that are going to expose them to just new vistas of liability that they would not otherwise have. So it is very complicated. It is it's a fraught area. And I agree that the tone of this is a little cold. And I think I think that represents a bit of a shift over time, where there was, at least at first, when, again, 5+ years ago, when I was first looking at this, the government was a little more sensitive and was trying to sort of be a little more open-minded, perhaps, or at least expressing a little more openness to companies about how they wanted to deal with it, and maybe understanding that companies may want to deal with these things in different ways. Going so far as to not even necessarily saying in guidance that it's a bad idea to pay ransomware ransoms, sort of leaving that sort of
Right.
unaddressed, like it's sort of a personal choice, you decide. For a while, at least, that was the position. I suspect that's changed over time, but in any event, yeah, this seems a little harsher, and it's now like everybody knows what the score is. Everybody should have gotten on board with these types of these issues, and you should have a better plan. And if you find yourself in this position, you're just gonna, you run the risk of making matters worse. And yeah, it's much more the scare tactic than the empathetic,
Like,
we understand tactic that which is maybe closer to where we started on this issue.
it is the vinegar approach as opposed to the honey approach. But I've represented companies that are victims not of a ransomware attack, but that are victims of various economic crimes. And to the extent they're in industries that heavily regulate the access to data, so in the ITAR space, or even in some of the high-level dual-use space in terms of information technology and the possible controls that you need to have on it, those companies are going to be very reluctant to walk in and talk about how they've been hacked, and that's been my experience. And then the hacked, and generally, if it's a ransomware attack, it's a hack and they've found stuff that is pretty sensitive. And so it's exposed holes in your controls. And so you're almost walking in, to the extent you've got, data control regulations because of what it is that you're storing, you're walking into the government and telling them, yeah, my controls were bad enough that this stuff got out of my company. You're essentially, put in the position of, I'd like to do something about this, but if I do something about this, I'm going to get myself in trouble. And this kind of doubles down on that, was my view.
Yeah, I agree on that. I mean, I think having been part of these discussions, the calculus is very complex and there's no easy answers here. Just all ransomware attacks do not necessarily result in blackmail. Sometimes they just take the blanket approach where they lock everything down and say, You can't have any of it, right? So they don't even necessarily need to know anything that's in the data. They just know that this is a business that's going to be crippled if the data is locked down, like most would be, and there's no redundancy or backup. So, but yeah, it is not an easy question, and we feel for again the increase in targeting that we've seen over the last 6+ months in the pandemic, I think is what has now stirred some more action and the feeling that this is something that needs to be put out into public. Again, this is one that will likely continue to evolve as people have new thoughts and new approaches to dealing with this. Also it strikes me that there has to be, although the OFAC regs are obviously strict liability on this, there's some discussion in the advisory about knowledge and what it means to have knowledge in this context if you're making a payment that might violate sanctions. And I think that's an interesting question, that if somebody ever got actually penalized for this and there was going to be a bit of a fight about it, or perhaps a lawsuit about it, then that might be interesting to sort of see how that would play out. And it would depend a lot on the facts, obviously, which could, there could be layers upon layers of interesting wrinkles there that would point you in one direction or the other. But I think that's just an interesting question to think about as well.
Yeah, I mean, that was just why my instinct was that the tone could have been a little bit like, you were the victim and don't make it worse by kind of inadvertently wandering into this minefield where it was like, once this happens, don't do this and don't do that, or you'll be in big trouble. And it's like, well, I don't know. But maybe the first approach was tried and it didn't work. Yeah. So.
Well, fear is the order of the day, in case you've been asleep for the last several years. So I'm not surprised to see that. But in any event, let's put ransomware to rest for the time being, and let's move on to our final full topic here before we head for home, and that's the recent Ofx settlement dealing with one of our favorite topics, Cuba.
Yeah, so this is a settlement action again from October 1st. So that was a big day in embargoed lore. Generali Global Assistance is a New York travel assistance company. It's kind of a back in the day settlement because it really deals with time and place where a lot of I think U.S. persons used to go to Cuba through Canada or through Mexico or through some third country, because back before the loosening in 2015, 2016, there weren't direct flights from the U.S. to Cuba, and so I think a lot of U.S. persons thought that was, the legal way to get to Cuba, when in fact it really was kind of fraught with potential OFAC violations. And I think a lot of U.S. travel businesses worked with Canadian travel businesses and Mexican travel businesses to arrange travel to Cuba. And it was common enough that a travel insurance company in New York worked with its Canadian travel insurance and healthcare travel insurance affiliate to provide healthcare insurance for U.S. travelers to Cuba. And what would happen is that they would, when the person would go to Cuba, the Canadian affiliate would provide the insurance after being passed the case from the U.S. affiliate, because the U.S. affiliate couldn't deal with the Cuba insurance because of the Cuba embargo, but their view was that they could pass it to their Canadian affiliate, who would then provide the insurance. There were reimbursement payments that were made on the insurance from the United States. So it was basically a systemic way of getting U.S. person business involving Cuba to be done by a Canadian affiliate. And that is generally a bad idea. I think people who understand this area know that is really the example that OFAC gives for facilitation, is essentially having a third party do something that a U.S. person isn't allowed to do and knows that they aren't allowed to do. And it wasn't just one example of facilitation. There were apparently 2,500, actually close to 2,600 examples of facilitation that took place over the course of years with this company. And the lesson here, I think, is they found out about this. They turned themselves into OFAC. There was a settlement. The settlement was around $6 million. I think the guidelines amount was $84 million because there were so many potential violations. And OFAC found that they were egregious. And I think the main reason that OFAC found that they were egregious is that this wasn't just something that they just did as a practice. They actually wrote it into their manual that this was the way you were supposed to deal with Cuba. And so if I would have kind of one takeaway from this, it is that while we're not providing legal advice here, if you want to create a manual as to how to deal with Cuba, you should pay someone to provide you with legal advice and to actually do that. If don't create a manual on Cuba if you're not going to do that, because you are going to create a manual that contains policies like this one, which I think really compounded the problem, because it was clearly a systemic problem that was ingrained into their compliance system, and that's as bad as it gets.
Yeah, I think the manual, the sort of codification of this referral process from U.S. to Canada in order to facilitate this business or potentially try to evade what they knew to be the restrictions on them, that's pretty bad. I mean, that's Exhibit A. That's why this was an egregious case. This was deemed to be an egregious case by OFAC. I think it just underscores a point that we've seen time and again, in particular with Cuba, which is this idea that if you are in the U.S. And you are a person subject to U.S. jurisdiction, you cannot sort of by proxy do business with Cuba. You just can't. And that's exactly what this company was trying to do. And when it all got sorted out in the end, OFAC came down on them, relatively hard. As Tim said, I think the fact that they disclosed this, the fact that this is very old conduct from almost 10 years ago, starting, I think, is the oldest. And then the rules got changed in the mid part of the last decade. And they even admitted in the notice that some of the conduct that was at issue here, that was the basis for the apparent violations, was later permitted after the changes. And so I think all of those things kind of mitigated, but that's kind of the big takeaway. I would also say, just as a general point, And to follow up on the discussion we had the last time with the changes to the Cuba regs relating to some of the general licenses that have gone away, the accommodations list that now exists, and the import restrictions against cigars and rum. This is just another shot at travel, tourism, and insurance,
Yep.
which seem to be, if you do a quick spin through recent enforcement actions from OFAC on Cuba, if you take out the big financial institution cases that involve Cuba processing of Cuba-related payments, they're basically all in this area. It's some aspect of travel, tourism, and insurance. And so this is clearly a strategic policy imperative for OFAC at this point to go after this, because it's seen as sort of one of the last main ways that the Cuban regime has still got a pipeline into U.S. dollars and U.S. revenues. And again, we'll see what happens on election day. If there's potentially going to be changes there. One last point I'll throw in here before we go to the lightning round on that point. I was having a discussion with somebody just a few days ago, and it came up the idea of whether the Cuba sanctions could actually go back to sort of Obama era Cuba sanctions, which were obviously on a road to being lightened significantly, if not completely lifted at some point. That Cuba apparently has made a big show, and I hadn't really focused on this, but I saw some of this, that they've made a big show about having some discussions with our friends in Beijing as something of a patron, perhaps akin to what Russia was for many years with Cuba. So if that continues, or if there's any real substance to those discussions that we start seeing evidence of, all bets are off as to whether or not there's going to actually be any change with respect to our policy to Cuba. But so I just throw that in as a bit of a wild card to kind of keep tabs on.
No, it's a great point. I mean, I definitely think that the stated policy of the Biden administration on Cuba has been to go back to the Obama era policy. But if Cuba were to strike an alliance with China, that would definitely throw a wrench into the mix.
Yeah, I think all bets are off at that point. So with that concludes the main portion of the episode for this week, and we will take a pause for our favorite sound effect. And now we are in the lightning round. 2 topics for the lightning round today: Iran and BIS, FedEx versus BIS. So number 1, Iran. As I said, we were planning to talk about this anyway, and then 2 hours ago, OFAC gave us a great gift, which is something even more to talk about here. So a couple of weeks ago, it came out that the U.S. was thinking about expanding sanctions in Iran, which, as we've talked about many times before, query whether any expansion of sanctions against Iran at this point make any real difference. Well, this is maybe one last area where perhaps there is some difference to be made, because it's focused on the financial sector. And in particular, what was rumored to be in the works and what has now in fact happened is that a number of Iranian banks, I think I counted 18, I looked at the list very quickly, were added to the SDN list today and are now subject to secondary sanctions, where they were not previously. And that's because under Executive Order 13902, which was issued earlier this year and was used initially to target the sort of minerals, precious metals, certain textiles sectors in Iran, has now been expanded to cover the financial sector. And these banks and these financial institutions are being sanctioned pursuant to that. Most, I believe, I haven't had a chance to check this yet because it's so fresh. I think most of these were previously sanctioned under Executive Order 13599, which meant that they were off limits. U.S. persons were blocked from dealing with them generally, with some exceptions that we'll talk about in a minute. But the rest of the world could do business with those banks and would not be subject to any secondary sanctions risk. Well, that's now done. And so now secondary sanctions are in play with respect to these banks. And that is potentially very bad news for the last kind of linkages from Iran to the rest of the global financial system. The one additional thing that I'll throw out here before I toss it to you, Tim. So this has purported to be for two reasons that this is happening. One is this is seen as a bit of these remaining banks were seen as a loophole that were still in play. 2 years after the full reimposition of sanctions following the U.S. withdrawal from the JCPOA, this sort of set of banks was still potentially in play. And by the reports, it seems that there's a feeling that there was still illicit trade and other things perhaps that maybe were happening and being facilitated through these banks, and that's why this measure is being taken now. And the second thing is Biden has indicated that if he is elected, he will make every effort to rejoin the JCPOA, and there's been some discussion that taking this step will sort of tie his hands a bit and make it all the more difficult. I think Tim and I have some, maybe don't agree with that 100%, but in any event, that's kind of the stated reason. The last point I'll make before I throw it to Tim very quickly is there has been a lot of hand-wringing and concern that this is going to really kill off any remaining sort of humanitarian aid and trade that's happening with Iran, which of course is in dire straits following the COVID pandemic and the general wear and tear of sanctions over the last several years. OFAC, it seems, in the guidance that they've issued and in the FAQs they've issued here, have taken great pains to make clear that that is not meant to be the case, and that these banks certainly, and that non-U.S. persons and U.S. persons alike can still do humanitarian trade with Iran. As we know, in reality, the answer there and how people choose to deal with that additional restriction is much more complicated. And then let me throw it to you on this, Tim. We were talking before offline about some of the interesting notes that we saw in some of the FAQs that were issued, in particular a promise that there would be more guidance with respect to non-U.S. persons and sort of what would not be considered significant transactions in this area, and that might be issued at the end of the 45-day wind down period that's afforded by the general license that was issued with this. What do you make of that? Because as we were saying, I think that's definitely a bit of a departure from how OFAC typically handles these types of things, and the sort of maximum chaos, confusion, and strategic ambiguity that they're looking to impart. And so, what do you make of that?
So, I mean, it's a recognition, I think, that there's kind of some real ambivalence about this move. It's been talked about for a while. And is apparently being really pressed by hardliners on Iran as the last hole to fill in terms of sanctions. But I think that, that it is, that on the other hand, you've got some of the more responsible people saying, I think, that, maybe we don't want to cut these banks off entirely. And in my view, this just, by painting with such a broad brush, it just strikes me as kind of a stupid move on the part of the administration if you're really seriously interested in sanctions compliance, because the banks that were put onto the list now, by all accounts, were the banks that actually were trying in Iran. That's why there were a bunch of banks that were on the secondary sanctions list. And those were the banks that were affiliated with the IRGC, that were involved in money laundering, that were involved in providing some payments for Syria. According to the administration, that's the stated ground for doing this. These 14 banks or 18 banks were the ones that got through because they had, at least they seemed to be doing better. And to the extent that the administration thought that there were particular banks that weren't, it could have put them on the list for that reason, and there wouldn't have been any controversy about it. But because they probably didn't think they had grounds to do that, they instead just put them all on the list. And in my view, it gives all of these banks now the incentive to just go rogue. I mean, what is the point in having a compliance system and actually trying to comply with international money laundering standards and international or anti-money laundering standards, and comply with, make some effort to comply with international sanction standards if you're going to get put into the same broad group as the banks that clearly weren't doing that. And so I think that it trades away the leverage that we had on those banks, because those banks had every incentive to stay on the right side of the line so that they would stay off the list. And this just says to them, basically, why bother? Because you're going to all be lumped together. So there's really no point in trying to do any of this. The thing that in terms of humanitarian trade, the guidance was interesting because it does seem to suggest that they are going to allow these banks to participate in humanitarian trade, will allow these banks to participate in some undescribed as of yet insignificant transactions, but we don't know what those are, but they are going to give guidance. And I agree with you, Brian, that is more than they usually do when they put banks on the list, although they usually actually have a better reason to put banks on the list than they did here. But what I really wonder about, and this is so new that I haven't had time to really think hard about it, but I'll throw it back to you, is what's going to happen with SWIFT? I mean, if these banks go off of SWIFT, then essentially you have no real SWIFT trade in Iran and international wire system into Iran. And so you create these huge incentives to have banks that are outside the international financial system. And that, to me, strikes me as kind of crazy policy, because we've spent the last 25 years just internationally in banking trying to push all the banks into kind of one system because it becomes much easier to regulate them. And if you push all the Iranian banks out, you create this kind of black hole that is going to be much harder to police. And so I get that the hardliners really want to crack down on Iran, but this strikes me as kind of a move that, if it really is run to fruition, is likely to backfire.
Yeah, I mean, I think the unintended consequences here and in many of these moves are always fascinating to think about. I agree that if you're, I mean, we've talked about this in with respect to China to some degree, the way that the entity list is now being used in China, sort of very broad brush, throwing just, large numbers of companies on the list for, reasons that would not have probably passed muster or been considered, 5 years ago. And I think this is sort of same. It's let's just paint with a broad brush, throw everybody on the list, and we're going to count on the fact that the fact that they are radioactive now is going to be a net benefit for us and is going to cause enough net pain for the Iranian government, the Chinese government, fill in the blank, to, I guess, help in the grand sort of, math problem that we're waging here on a foreign policy battle. I don't know that that's necessarily true or even really provable. I mean, time will tell. I would also say that, again, it strikes me that if anything gets undone quickly with respect to Iran under a potential Biden administration, it could be something like this, where this group just gets put back on the 13599 list, essentially, and U.S. persons are still off limits, but everybody else, no secondary sanctions. So I don't know. We'll see. But yeah, I think this is very new. Again, literally, this just came out 2 hours ago. So
right.
we've taken a first quick spin through the FAQs and through the general license and thinking about this. I'm sure we'll come back to this at some point in the future, but yeah, for now, we'll have to see. So. Okay, that was not very lightning, but at least
it's
that
a
was
big topic, and it became bigger. I think we put it in lightning before we knew there was going to be a big development today.
We'll give ourselves a break on that one. So with that, let's move on to the last lightning round topic of the day, which is FedEx versus BIS and the outcome of that.
So this is going to be another case where we're going to do a little Monday morning quarterbacking, but let me just set the stage very quickly in a lightning fashion. So FedEx is obviously a common carrier, carries tens of thousands, if not hundreds of thousands, maybe millions of packages a day around the world, a lot of packages a day. And some of them cross international borders. I'm sure many of them cross international borders. And so, like many common carriers, FedEx, they take shipments from their customers and they carry them. And, how that interacts with the export laws is sometimes not very well, because essentially if the shipper has export duties, but if the shipper doesn't follow that, then FedEx is the one who's actually carrying these exports across international lines. And the way that the export laws read, it's clear that a carrier can potentially have export duties, and the BIS has read the regulations that way. FedEx recently, and it's described in the opinion, got in trouble because it was delivering packages for its customers to end users that were on the entity list, or was delivering packages that were not allowed to be exported from the United States without a license. And so, and the theory of liability that BIS imposes against a common carrier like FedEx has traditionally been aiding and abetting. So they find that they are aiding and abetting an unlawful export because the exporter itself is generally the shipper. FedEx brought a lawsuit that said that this application of the export administration regulations to FedEx violated the Due Process Clause, violated the Administrative Procedure Act, and violated ECRA. And the argument was that because there was strict liability under these laws, that there was just no meaningful way that a company like FedEx could comply. And so neither the statute nor the Constitution allowed BIS to impose this sort of strict liability like this. Now we get to the Monday morning quarterbacking, and then I'll turn it over to you. So that was the theory of the lawsuit. The judge rejected the claims. The judge went through and found that common carriers can be, that both the Constitution and the statutes allowed common carriers or allowed BIS to impose strict liability against common carriers for these sorts of export violations. And he found a little bit of difficulty with one of the statutes as to whether or not there was a mens rea requirement, but he found that, it was ambiguous, and BIS could impose such a requirement in those circumstances. Okay. So I found that ruling relatively unexceptionable. I thought that the last issue probably could have gone either way, but still, I thought that there is strict liability, or there is pretty established law for civil strict liability across both the DC Circuit and across in the Supreme Court cases for certain types of regulatory crimes. It is or regulatory offenses, and it's civil liability. It's not criminal liability, and so strict liability doesn't seem to be per se out of bounds. The argument that I didn't see, there was a working assumption that aiding and abetting liability was strict liability. I know you and I have represented common carriers before, and I have argued in front of BIS, and BIS has never responded to it. And we've always essentially won the case, so we've never really challenged it. That aiding and abetting liability is not strict liability. That the term aiding and abetting has a common law meaning that includes a mens rea requirement, and so there's no, you can't interpret it as strict liability. And BIS has never taken a formal position on this. Now, this lawsuit was conducted under the presumption that BIS was interpreting as strict liability, but I didn't see it there, and I haven't gone back all the way through. Maybe somebody argued it somewhere, but I really would have wanted to push harder on the argument that, if aiding and abetting liability was possible in this area, but it included a mens rea requirement, and it had to include a mens rea requirement because that's what the term aiding and abetting means. And I didn't see that argument pushed at all, and I thought that was a better argument than the ones that were raised in the plea.
Here's I have sort of two big points on this that are that sort of relate to that comment. One is, just for context, for those who didn't follow this when it first got filed, this was filed in the wake of Huawei being added to the entity list last year. It got filed, the lawsuit was filed in June of 2019, a month after Huawei was added to the entity list. And I think there was a feeling at the time by FedEx and others that the requirements to comply, in particular with respect to Huawei, would be so onerous that they would just have to, their business would grind to a halt and they wouldn't be able to operate any longer. So that's kind of, I'm sort of paraphrasing, but that's my understanding of sort of what animated this in the first instance, right? So that's number one. Number two, related to what Tim just said, and this discussion, this sort of very interesting discussion about mens rea and knowledge, et cetera, that we saw in the opinion, a very thoughtful, well-written opinion by a very wise judge, who
very wise judge
was there was no injury here. we're not in a situation like,
Right.
again, the ExxonMobil case where they have a penalty imposed against them. Here, they don't. This is all prospective. It's all speculative. It's all looking at, well, we can't comply with this entire regulatory regime. As a
Right.
general matter, again, not to sort of second guess too much here. Those are not the type of challenges that fare very well in this area. If you have a concrete, particularized, specific, fact-based harm that you can point to and say, here's why, in my case, this is unfair, unjust, unconstitutional, illegal, etc. Your chances of success are far greater than these sort of very broad, sort of diffuse challenges to this entire. Essentially, they were just taking on the whole EAR and saying the way it's all set up is hooey and it needs to go. And I mean, again, that's that's a drastic oversimplification, but that's sort of where we were here, is that there was just no real case or controversy or concrete injury. So I understand that's why you seek declaratory relief in the first instance to avoid that. But at the same time, when I thought about that more, I'm just like, that's the kind of case that you're going to need to have to flesh out this point that Tim raised about
let's put on this, and let's make it real with your example, Brian. So after Huawei goes on the entity list, I mean, carriers are carrying tens of thousands, hundreds of thousands of packages a day to Huawei entities around the world. And people are probably still trying to ship them even after Huawei goes on the entity list, at least a number of them. And the carrier puts into their screening system Huawei, and let's say they catch 48,000 out of the 50,000 packages, or 49,000 out of the 50,000 packages, and 1,000 get through, because screening that sort of volume is really hard, because you've got to do it so fast, and you've got to, the screening software has to be tuned correctly. But if it's tuned too high, then there's too many hits, and you got to have enough people to go through all the hits and figure out what's a real hit and what's not a real hit. And so there are going to be mistakes that are going to be made when you're dealing with that kind of volume. If BIS imposes a penalty for aiding and abetting liability in those circumstances, especially if they impose any sort of big penalty against FedEx for missing things in screening, if FedEx could show it had a great screening program in place, it was doing its best, and it missed a few things, and they imposed some big penalty on that, I think if you come in with the argument that sort of liability isn't permitted by ECRA, which was their argument there, or with the argument that to impose aiding and abetting liability, there has to be some sort of mens rea, meaning that if you showed that they had no compliance program, or if you showed that their compliance program was kind of willfully missing all of these things, or that they had notice of this and hadn't done anything to fix it, fine. Like, there is some room for that, but if the facts are that they're trying their best, and that the volume just got so great because a new company went on the entity list that had a huge volume of deliveries, and they stopped most of them, but a few got through, like that I think the regulators, if you got them off the record and on truth serum, would tell you that's not what they're going after. That is not something that really is the proper subject of the export laws. And if somebody got it in their head that they were going to go after that anyway, I think that's the sort of case that you would want for a challenge, and not one where it's basically you can't apply these laws to us because it's just too hard, is just not the posture that you want to be in.
Right. I agree completely. And I would just add sort of one final point there, which is I'm paraphrasing. I'm going to be paraphrasing here, but there was a portion of the briefing that talked about the idea that in other statutory regimes, there are exceptions for common carriers that protect them from liability in these types of scenarios. And essentially, the briefing kind of made the case that it's unreasonable not to have such protection for common carriers in this context. And I believe it must have been the government's brief, said something like, this lawsuit is essentially a policy preference in search of a legal claim. And I think there's something to that. And the idea that in the Export Control Reform Act of 2018, when perhaps this issue wasn't quite as front and center as it is now, because we didn't have Huawei on the entity list, and we didn't have the sort of enforcement posture and just the pace of, additions to the entity list and the SDN list that we do now, maybe it would have made sense to consider that. Maybe it was considered. I would have to go back and look at that. But in any event, there is no such exception for common carriers under
Right.
ECRA. And if this is the end of this litigation for now, at least in this form, then I wouldn't be surprised to see that there could be a run taken at this issue in whatever the next version of export control sort of tinkering or reform is at some point in the coming years.
Yeah, and I mean, to the extent there's an exception in this area, it strikes me that you'd likely want it to be a good faith exception. Basically, you do want the carriers to be part of this because they do have the resources to do it. It's just that they're not going to be, no matter how hard they try, given the volume, there's going to be stuff that goes through. And so what I think you want is to give them the incentive to do their best so that they become one check. The shipper is another check, and usually the bank is a third check, so that you have multiple checks in the system, so that at some point these sorts of shipments get stopped before they go to the wrong party. But having strict liability for carriers in these circumstances strikes me as insane. And I'm not even convinced that when under the aiding and abetting theory that BIS has, that it really is strict liability.
Yeah. Well, that'll be for another day when Tim and I are on the briefs for some other common carrier trying to make that argument in front of the district court in DC. So with that was a decidedly non-lightning round, but those two issues were pretty complicated, and we wanted to sort of wade through them a little bit. So apologies for those who love brevity. If you love brevity, you probably don't like this podcast very much anyway.
You have ditched us long ago.
So fair. So, but in any event, that's all we have for this episode. Thank you as always for joining us. We are just looking at the calendar here. We are a little more than we are basically just 3+ weeks away from the election. I think we're going to be we will do one more that we record that will get posted. This will be up probably October 13th. And then we'll probably do one more episode that'll go up just the week before the election. And then we will probably be recording toward the end of the week of the election. And it may very well be that that's all we focus on, is sort of what do we think this means, if we even know what it means at that point, which we may not. So
can't trust
in any event. Thank you
election.
Well, that is not the point that I'm trying to make. But we will try have faith in our election. But thank you as always for joining. Again, if you're a fan of the pod, please subscribe, give us a 5-star rating. You can find us anywhere: Apple, Spotify, Google, Stitcher, Overcast, YouTube. And until next time, stay well, and of course, stay sanctions free.
Stay sanctions free, everybody.
All right. Thanks, everyone. Bye.